Millions of people mailed 23andMe something they could never replace: their DNA. The company turned a tube of saliva into ancestry reports, health insights, family connections, and a research database with extraordinary scientific value. Then came a breach affecting 6.9 million people, collapsing revenue, a leadership crisis, and Chapter 11. The original public company was sold, but the genetic information did not disappear. So who controls it now? 23andMe collapsed as a public company. Its database survived. Founded in 2006, 23andMe packaged complex laboratory genetics into a product that felt almost effortless. Buy a kit. Spit into a tube. Mail it back.
Then open a website that translated selected genetic variants into ancestry estimates, traits, family matches, and later, authorized health risk reports.
The breakthrough was not only scientific. It was product design. 23andMe made genetics feel personal, visual, and shareable, something ordinary consumers could explore without beginning in a clinic. Regulatory progress helped turn novelty into legitimacy. The FDA lists 23andMe among authorized direct-to-consumer genetic health tests. In 2021, the company announced a public market transaction at an enterprise value of about $3.5 billion. Investors were not valuing a plastic tube. They were valuing a platform, a recognizable consumer brand, a growing genetic database, and the possibility that research insights could become new medicines. The consumer product had a structural problem. A DNA test is naturally infrequent. Customers did not need to repeat their ancestry every month. 23andMe tried memberships, premium health services, and telehealth. But its filings still said personal genome services generated 74% of fiscal 2025 revenue, while membership services represented 19%. Total revenue fell from $299.5 million in fiscal 2023 to $219.6 million in 2024, then $189.9 million in 2025. The company needed continuing growth from a product many people bought only once. The database offered a second path. As of March 2025, 23andMe said more than 80% of customers had consented to research. Their de-identified genetic information could be combined with surveys about health, traits, and lifestyle. In 2018, 23andMe entered a drug discovery collaboration with GSK. The vision was powerful. Consumer curiosity would create a research engine, and that engine could identify drug targets. But the filing also said substantially all research services revenue had come from the original GSK agreement. The database was strategically valuable. The revenue model around it remained concentrated. Then the network effect worked in reverse. The attack began with credential stuffing, usernames and passwords reused from earlier breaches elsewhere. About 14,000 23andMe accounts were directly accessed. But the service was built around connections. DNA relatives and family tree features linked one account to information about many others. The exposure expanded to approximately 6.9 million people, although the exact data visible varied by profile. Regulators later criticized weak authentication, monitoring, and response. The lesson was brutal. A feature designed to reveal family connections also widened the blast radius when security failed. The fallout continued long after the headlines. In June 2025, the UK Information Commissioner fined 23andMe £2.31 million over security failures affecting UK users. In July 2026, a coalition of attorneys general announced an $18 million recovery from the bankruptcy estate and new security requirements for the remaining data. A separate class action settlement in the bankruptcy was reported at $46.75 million for eligible claimants who had filed on time. These figures belong to different proceedings. Together, they show how a privacy failure became a lasting financial and legal liability. Financial pressure became a governance crisis. In September 2024, 7 non-employee directors resigned, saying they differed with CEO Anne Wojcicki over strategic direction and pointing to her concentrated voting power. In November, the company approved a reduction affecting 223 employees, about 40% of the workforce, and closed substantially all therapeutics operations. In March 2025, a special committee rejected Wojcicki's 41-cent per share proposal. 20 days later, 23andMe filed for Chapter 11, and Wojcicki resigned as CEO so she could participate as an independent bidder. The company had run out of time. The database still had buyers. By March 31st, 2025, the filing showed only $38.2 million of unrestricted cash and an accumulated deficit of $2.5 billion. Revenue had been falling, the therapeutics bet had been shut down, and litigation remained unresolved. Chapter 11 allowed the business to keep operating while the court supervised the sale. For customers, that meant something unusual. The service could continue even as the company that collected the data prepared to transfer its core assets to a new owner. The first announced buyer was Regeneron at $256 million. But the auction reopened. TDM Research Institute, a nonprofit public benefit corporation founded and led by Anne Wojcicki, offered $305 million. TTM won. The court approved the transaction, and the acquisition of the Personal Genome Service and Research Services assets closed on July 14, 2025. The database did not disappear into liquidation. It returned to an organization controlled by the company's co-founder, under a new nonprofit structure and new privacy commitments. Today, the core consumer genetics and research operations are controlled by the organization now presented as 23andMe Research Institute, formerly TTM Research Institute. The current privacy statement applies to websites and services it owns and operates. TDM promised to follow the existing privacy policy, establish a consumer privacy advisory board, report on privacy procedures to attorneys general, and continue deletion and research opt-out choices. Those commitments matter, but they do not change the central fact: control of a uniquely sensitive database passed through a bankruptcy sale. Customers still have choices. The current service says an account can be deleted through account settings. After confirmation, access ends, future research use stops, and any stored sample is discarded. The company recommends downloading personal information first because deletion is irreversible. But deletion is not magic. Limited records may be retained when required by law, and information already used in completed research cannot always be pulled back from published or completed work. The practical right is control going forward, not a guarantee that every historical use can be undone. The larger weakness is that American genetic data protection is fragmented. HIPAA protects genetic information when it is held by covered healthcare entities and their business associates. It is not a universal privacy law for every consumer genetic service. GINA restricts genetic discrimination in health insurance and employment, but it does not cover life, disability, or long-term care insurance. States add their own rules, creating a patchwork. Legal disputes continued after the sale. In July 2026, A bankruptcy judge limited California's attempt to seek monetary relief from the former debtor entities, while other remedies remain possible. That dispute was still developing and must be rechecked before publication. 23andMe did not collapse because people stopped being curious about their DNA. It collapsed because curiosity created a powerful database without creating a sustainable business around it. The service survived under a new nonprofit owner, with privacy commitments and deletion rights. But the episode revealed a risk larger than one company. A password can be changed. A credit card can be replaced. Your genetic identity cannot. Subscribe to Company Shift for the decisions, systems, and hidden risks behind the companies people trust every day. And watch next. The app update that broke a billion-dollar brand, Sonos. What would you do with your 23andMe data today? Keep it, download it, or delete it?